This is the type of stuff that keeps me doing labor and employment law, because I will always say people do the funniest things at work. It depends on what exactly this person is talking about. So if they are just out there stumping for a particular candidate, there's really nothing against the law on that, at least here in Florida. Now, you may not want that as an employer because you want to keep your workforce like normal and happy and nobody's all tense about like political discussions. In other states, you actually may get in trouble for stuff like this. It depends on whether it's on duty, off duty, all that sort of stuff. But where you really start getting into more trouble is depending on what exactly this employee is talking about, right? If they're just out there talking about a candidate for the sake of like supporting that candidate, you can give this guy a slap on the wrist for it. Now, if they start talking about, we should vote for this candidate because he supports X, Y, and Z issues, many of which can often relate to employment-related issues. So you wouldn't be surprised to hear that political candidates are talking about things like wages and unions and discrimination and diversity, equity, and inclusion, all those sorts of things. If the employee is kind of referring to the candidate's position on all those things, you actually might be getting in trouble if you discipline this employee, because that could be considered protected concerted activity under the National Labor Relations Act, whereby an employee, whether unionized or not, is free to talk with other employees about workplace conditions and other terms and conditions of employment. There's a ton of other variables to go about this, like whether or not it was happening in the break room, whether this was happening on time that people were supposed to be working, whether other people were even talking about it, or was this guy just talking to himself, all those sorts of things.